Chris, if able.
My Lord, I was just finishing my second core submission.
Yeah.
And the last point I wanted to make about section 2.4 is that because it requires the court to consider whether or not the claim would in fact be statute barred had it been brought against the liquidator of Heatwave directly. That also reveals in my submission why it makes no difference to the time bar analysis as to whether or not the insolvent insured is in fact joined as a party under section 2.9 or not. The reason for that essentially is because it's the same cause of action in any event, and it's only, in my submission, only if the claim would be time barred had it been brought against the liquidator of Heatwave that the insurers would have a limitation defence in the context of a declaration under section 2.2a, and that's my primary case. My Lord, the third and fourth core submissions, I had a look at my notes, and I have to say I've either already alluded to, or in fact in some cases made the points expressly already, so I'm going to hopefully take these slightly more quickly than I had initially anticipated. So, although I have been a little longer than I thought with core submissions 1 and 2, this actually should not go too slowly now. The third core submission is this, namely, if I'm right that section 2.4 requires the court to ask the hypothetical question, would Heatwave have had a limitation defence to the appellant's claim to establish liability if proceedings had been commenced against Heatwave itself in October 2020? If that is, as I say it is, the right question, then one needs to consider what is the right answer. And the answer, in my respectful submission to that question, is no. And the simple reason for that is as follows. That because the company is in liquidation, and because the liability existed and was not statute barred as at the date of the winding up order on the 4th of March, it necessarily follows, in my respectful submission, that the liquidator would not be entitled to say that the claim was time barred. And the reason for that is the principle, or rather the effect of the principle established in rolling stock. Now I say established in rolling stock, there are in fact, as the case is revealed, earlier instances of the same principle being articulated. It's just that I'm calling it the rolling stock principle because that's the way it was described by Lord Justice Lloyd in Larnell for convenience. But the principle itself is long-standing. So that's the answer in my respectful submission. In other words, had my clients brought proceedings directly against Heatwave, the claim would be, we would respectfully submit, on all fours with the claim being considered by the court in Larnell. And for that reason, the liquidator, the company, in the insolvent company, would not have a defence based on statute of limitations. And that being the case, the insurers can be in no better or different position than the insured, and equally would not have a limitation defence of its own.
So if the claim became time barred before the company goes into liquidation, then the liquidator would have had a time bar defence and so does the insurer. But if it's still extant at the time when the company goes into liquidation, as a result of rolling stock, you suspend the limitation period and therefore there's no defence available either to the liquidator or to the insurer.
Exactly, my lady. It's exactly my case.
Yeah.
And
Right.
Now, just to briefly go through the reasons why a liquidator wouldn't be able to say the claim falls outside the liquidation. I mean, these are articulated in Larnell. Very briefly, there's 4 reasons. One is some and possibly all of the claim, all of the loss that my client suffered as a result of Heatwave's breach of contract and duty may or may not be recoverable in either the liquidation or in the insurance or under the policy of insurance. It's simply not known. But on any view, the second point is that it's a mixed claim because it definitely does include uninsured losses, although the extent of the uninsured losses is uncertain. But that is enough in my submission for it to amount to a claim which the liquidator cannot reject on the basis of being time barred. Thirdly, it can make no difference what the purpose, the subjective purpose of the bringing the claim is. This is the point that Mr. Tolley argued in Larnell that was rejected by Lord Justice Lloyd. The purpose can't matter. At the end of the day, what matters is the fact that it's the same cause of action. And being the same cause of action in relation to a single loss is either, as Lord Justice Morbick put it, is either time barred or it isn't. And then finally, the final reason is because, as I explained earlier today, I'm sorry if I'm repeating myself, the appellants are not in the same position as a secured creditor. And the reason for that is because the rights, at least the substantive rights under the insurance policy, notwithstanding the existence of the procedural rights under Section 2 of the 2010 Act, the substantive rights under the insurance policy remain incoherent because they're dependent for their exercise upon establishing the liability of Heatwave and the coverage issues being resolved in favour of the third party. So that brings me to my final core submission, which is this, and I made this point already, but I'm going to nonetheless return to it and try and articulate it as I would have hoped done when I first skirted with the point. And it's this, that the purpose, or at least one of the purposes of the 2010 Act, was to simplify and improve the rights of the injured third party in pursuing his claim against an insolvent, the insurer of an insolvent tortfeasor or contract breaker. And given that is the purpose, or at least one of the purposes of the 2010 Act, if my lady friends are right, and the judges below were right in saying that the insurer had a defence by way of limitation to a claim for a declaration under Section 22A, which the liquidator would not have had a claim being brought under the two-stage process which is preserved by the 2010 Act against the liquidator of the company directly, then that would, in my respectful submission, frustrate and undermine the purpose and rationale of the 2010 Act. And it would be, using the phrase Merkin and Collinverve adopted, albeit I agree I'm lifting it out of there, and it would be utterly bizarre, in my submission, if that were right. In my submission, when you come to look at my own friend's argument, it's conceptually impossible for a claim, for a declaration of liability under Section 22A to be time barred and then subsequently become free of a time bar at a later date if the court determines that the policy does not respond to my client's claim. It's precisely because of that uncertainty that when the claim was first commenced in October 2020, which is the date by which the question of time bar in my respectful submission is to be determined, it's precisely because of that uncertainty, well, that's one of the reasons why the claim was outside the liquidation and therefore was not time barred. So, my lords, my lady, those are the four core submissions that I wanted to advance in support of the appeal. The essence of our critique of the judgment of His Honour Judge Khan is that he simply adopted the wrong approach. In particular, he failed to recognise the fact that for the purpose of the relevant inquiry under Section 22A and 224, it was necessary for him to consider to what extent the liquidator of Heatwave would have had a limitation defence to a claim had it been brought against him. Had he recognised that that was the right and relevant question, and had he had regard properly to Larnell and the fact that the considerations the Court of Appeal relied upon in that case are equally applicable here, he should and would, in my respectful submission, have reached the conclusion that the claim was not time barred.
In essence, what you are, I think, saying is, firstly, we should, as the court always try to do, give a progressive construction to the Act. And secondly, underlying the way the Act is framed is at least the assumption, which may or may not be strictly correct, that a defence based on the Limitation Act is a substantive rather than a procedural defence.
Well, I'm not necessarily sure whether that is necessarily the assumption. What I would say is this, that whether the defence of limitation is described as a substantive or a procedural defence, the consequence of it is to preclude the exercise of a substantive right.
Yes, absolutely, by a particular procedural means, i.e. by action.
Yes.
And there are plenty of cases which say that a statute barred debt is still due, it's just not enforceable by action. So the argument against you would be that by changing the procedure, and general rolling stock is again procedural. This is what general rolling stock says is the way to enforce a debt against an insolvent is through the insolvency. That is the only way you can do it. Even if you've got a judgment, you still have to go through the insolvency to enforce it. So the argument against you is that a change in the procedure may have the effect of precluding the enforcement of the underlying substantive right. So I think it is inherent in your argument that a limitation defence is a substantive defence, irrespective of the procedure by which the claimant seeks to enforce the debt. And if it doesn't apply when he seeks to enforce through the insolvency, it doesn't apply when he seeks to enforce through action.
My Lord, I'm not sure that my case is entirely dependent upon that assumption. The reason I say that is this, that it would be firstly, it'd be very, very odd, put it no higher than that if the different procedural routes that were adopted could lead to a different result in terms of limitation. And in that respect, I can remind you what both Lord Justice Lloyd said in Larnell, and also what Mr. Justice Blackburn said in Eurocrit. So that's the first point. Second point is, I do accept what your Lordship says conceptually is right, namely that the procedural situation could have an impact upon the outcome of a substantive dispute. So conceptually I accept that. But it's not a problem, in my respectful submission, here. And the reason for that is because what Section 2.2a and Section 2.4 do is they actually combine together the two procedures that are relevant here. And the reason they combine together the two procedures is because Section 2.2a requires the court, for the purpose of determining the answer, to ask the very question: what would the liquidator's position have been had the claim been brought against it? That procedure. And therefore, if by that procedure the liquidator had no defence based on limitation, by definition it follows the insurer could be in no better or different position. So that's my argument. I don't think it depends necessarily upon the assumption, although I accept that the analytical basis on which you put the point, my Lord. Can I then finally deal very briefly, and I've already done this to some extent, with the respondent's notices point. They obviously, these have been dealt with in writing, and my own friends FCS have got some points to make. But I do want, if I may, to say two things. One is, as far as Cox and Bankside is concerned, I don't fully understand the point. So I'll have, if I've misunderstood it, I'll come back to it in reply. But my submission would be that the Cox and Bankside point is a complete red herring, dealing with a very different issue namely the question of how insurance claims are paid out when there's a limited fund and multiple claimants at a much later stage. It doesn't deal with the question of establishing of liability, and nor does it deal with the question of time bar in the context of the 2010 Act. So the Cox and Bankside point is a red herring. The perpetuity point is a point. I accept that, and you've seen that Professor Merkin and Colin Vaux touch on it in their most recent edition. FCS is going to deal with the point, as far as I'm aware, to some extent, and I've already offered one idea, which is the specialty argument, which I did articulate this morning. And although I was going to deal with it at this point, in fact, I'm not sure I've got anything to add to the point I was going to make. The reason just to reiterate it for the purpose of your note, because I'm sorry I've gone slightly out of my order, but the specialty argument is this, that ordinarily a procedural right cannot give rise to an independent limitation period. One is solely concerned with the substantive cause of action to which the declaration relates, which in this case, of course, is the cause of action by my clients against Heatwave. And that is the ordinary situation. What may take this case slightly out of the ordinary is the particular requirements of the statute, which is the only route, of course, by which a declaration could be sought by my clients against the insurers in relation to a different party's liability, is the fact that it requires, as part of its necessary factual makeup, to establish that the party has become that the insolvent insured has become a relevant person for the purpose of the statute. That's a necessary ingredient to the ability to bring the claim for a declaration. And it's because of that particular feature that in terms of analysis, this could be a situation where a long stop date, being 12 years from the date claim under section 2.2 could be brought, may well provide an answer to the perpetuity point. But I have one final answer, if I may, to this conundrum, which is this, that even if, by reason of the introduction of 6A, there's this small lacuna, it is only small, there's this small lacuna in the Act whereby no limitation period can apply, and therefore there is a risk of stale claims in relation to dissolved companies that were previously insolvent. That's the situation. The court, in my respectful submission, still has tools in its toolbox to deal with the problem. And the particular tools I'm thinking about are the ones that Lord Hodge referred to recently in his judgment in a case called Smith and Burrell, which is in the third bundle of authorities. Clear the deck slightly. It's in the third bundle of authorities, my lord, my lady, at tab 51. And this was a case about PPI liabilities, and of course we know that they have ended up giving rise to a long tail business as a result of the Consumer Credit Act and the end of relationships. And one of the issues that arose was whether or not stale claims were time barred or not. And the particular passage, it's a different factual situation I quite understand, but it's the way in which Lord Hodge approached it, which I submit is of potential assistance here. The point I want to deal with is the one that emerges from paragraph 89, page 801. And Lord Hodge says, the bank states that if the relationship between the bank and the debtor continues, this interpretation exposes the banks to continuing claims relating to PPI policies long after the PPI mis-selling scandal has become stale. The Limitation Act 1980 has no relevant long stop date. So that's the potential problem that my own friends rely upon. There's no long stop date here in relation to dissolved companies. And Lord Hodge says, notwithstanding that people have been aware of the PPI mis-selling and the provision of regulatory compensation for such mis-selling for many years, it is feared that a continuing relationship between the debtor and the bank will give a green light to a claim. The answer to this concern, to my mind, lies in the discretion which Parliament has given the court in relation to the appropriate remedy, if any, which it chooses to give. If a debtor sits on his or her hands in knowledge of the relevant facts, it would be, as Lord Legate states, inconceivable that a court would think it just to make an order under Section 140B of the 1974 Act. This is so both during the currency of the relationship and the 6 years after that relationship had ended. And just bearing in mind the language he refers to there, particularly in the sentence, the answer to this concern, to my mind, lies in the discretion which Parliament has given the court in relation to the appropriate remedy, if any, which it chooses to give. And just bearing...
Then stuck with section 2, subsection 3, which is mandatory.
My
So
lady,
there's no discretion at all.
that's completely right, but the point I'm about to make is, when you look at subsection 6, my lady, which is when it comes to consider what judgment to give, what we see there is where the court makes a declaration in this section. So my lady's quite right that the obligation by virtue of section 2.3 is that if one is entitled to a declaration, then there's no discretion to refuse it. But the key point I want to make is this, that the language of language of section 2, subsection 6 mirrors, we would submit, exactly the language that Lord Hodge uses in paragraph 89 of Smith and Royal Bank of Scotland. In that the 2010 Act says, where the court makes a declaration under this section, the effect of which is that the insurer is liable to P, that's the third-party claimant. The court, and then the key word here is may, so that's the first point, it's a discretionary provision. And then the second point I want to make is, go on, say, give the appropriate judgment against the insurer. And as I say, that in my submission is chimes with what Lord Hodge has said at little d of paragraph, page 574 of the internal pagination, page 801 of bundle A3, namely that the answer to this concern, which is the concern of stale claims, to my mind lies in the discretion that Parliament has given to the court in relation to the appropriate remedy, if any, which it chooses to give.
So the third party brings an action, gets a declaration, the court says, well, as a matter of discretion, we're not going to enter judgment against the insurer. All right, says the third party. Section 12.4 tells me that time now runs against the insurer from the date when I establish the insurer's liability, so I bring a new action. Now, what's to stop that? Is that just an abuse of process point? Or was there a substantive point there?
But my lord, you're quite right. There is a 6 year period that doesn't even begin until liability has been
So
established.
I've got my declaration, but the court, for discretionary reasons, declines to give me a judgment against the insurer.
But the point that my learned friends make is they don't deny the fact there is a limitation period that applies. They just say it could be triggered at any point in the future. So they say that the fact there is, in a sense, a long stop of 6 years from the date liability is established doesn't assist the claimants in avoiding, doesn't assist the insurers in avoiding stale claims. That's their point, as I understand it. And the point I was making is that in any event, 2.6 still gives the court a ability to give a remedy, and that could create an issue of stop and raise judicata, preventing any further claim, and of course there's general abuse of process. But there is another point, which is this, and I think it comes out of Lord Legate's speech, or judgment rather, in the same case, if I'm remembering this correctly, forgive me for a moment. I was thinking of paragraph 58, although there may be another one. Paragraph 58 of Lord Legate in Smith and Law Bank of Scotland, where he refers to the fact there are some types of claim which are not subject to any statutory period of limitation at all. One example is claim for specific performance. Another example, though this sentence now needs to be corrected in light of recent developments, but he does say, I'm sure, but without, and based on an assumption, which wasn't, of course, correct, that another example is a petition for relief under 994 on the ground of unfair prejudice. Where there's been delay in issuing such a petition, the court's approach is to consider how the delay should affect the exercise of discretion under 966. If in view of the delay and the reasons of delay, it's unfair in all the circumstances for petitioners to obtain the relief they seek, the court will exercise its discretion to refuse it. Now, I'm very, very sorry. If I could have a moment. I thought there was a passage where he said the court should be robust to to exercise the discretion at an early date, case management terms. I've got mixed up. I was thinking actually of Lord Justice Snowden's concurring judgment.
Yes.
Exactly. Yeah. Sorry, that's what I was thinking of. So that was the point I wanted to make. So, my lords, unless I can assist further, those are my submissions.
I've got one more question. I'm sorry to badger you.
Not at all.
There are a number of different circumstances in which somebody can become a relevant person. We've been focusing on liquidation. But another is where a mortgagee appoints a receiver, see section 6(9)(a). That doesn't stop time running, so the claim would have to be brought in 6 years, would it?
Yes.
So, depending on how a person becomes a relevant person, there may or may not be a limitation period, and that limitation period may differ according to circumstances which cause somebody to become a relevant person.
My lord, I think that must be right. It's the rolling stock principle is a feature of winding up, and equally, the rolling stock principle will not help a third party if his claim has already become subject to a time bar before the voluntary winding, or the compulsory winding up order is made.
That was the point I put to you earlier.
So I hope that's of some assistance.
Yes, thank you.
Thank you very much, Mr. Bailey. Thank you. Mr. Lynch.
Did you have what in insolvency circles they call a waterfall?
Yes.
No.
Sorry about that.
I noted it.
Yep. May it please the court, I appear on behalf of the FSCS with my learned junior, Gillian Hughes. The first point I'd like to make is just to say how grateful the FSCS is to the court for permitting some submissions to be made. For reasons set out in evidence already, this is obviously a matter of great importance to the FSCS as for other claimants. I'd like to address the court briefly on 4 points. The first is the role of the FSCS and its relevance to this appeal. The second is limitation in the context of declaratory relief. The third is protecting the efficacy of the Section 2 procedure. And then, to the extent that there is time, fourth, some points on fairness or unfairness. My learned friend, Mr. Bailey, has covered a number of the points that I was going to make. And it seems to me quite clear that the court has those points. Now, what I really don't want to do is waste the court's time. And so if it's obvious that we're trespassing on repetition, I'll take the hint very quickly and move on. So it may be, in fact, that I'm much quicker than my allotted time, and it might be sensible, but obviously I'm very much in the court's hand. It might be sensible for me to have a bit of time in reply because
Yeah,
But-
I
but
can see that we indicated that we would keep an open mind on the topic. I understand the point.
I'm grateful. So if I could just turn briefly to the role of the FSCS and its relevance to this appeal. The starting point is, please, in Core Bundle 2, behind tab 78. And this is the witness statement of Mr. Derbyshire. Now, maybe the court has already read this. I will then just skip through it just to highlight a couple of points. So again, I won't take much time on this. The FSCS obviously runs a compensation scheme established under FSMA 2000. The relevant rules are the comp rules and the PRA rulebook. The relevant test, as we see set out here, paragraph 8, is where there's a valid claim to be made by an eligible claimant. The valid claim is to be in respect of a protected claim against a relevant firm who is in default. If the claim meets the qualifying conditions for compensation, the FSCS will determine the amount of compensation payable. That's up to £85,000. Will pay the consumer and then take an assignment of the consumer's rights. And that's really the crucial starting point, is that the assignment that's taken. As is made clear in the evidence, further on in the evidence, the FSCS pays out very large amounts of money every year. So two examples are in 2021-22, the FSCS paid out £584 million in compensation. And in the 2023-24 financial year, this isn't a crystallised figure yet, but it's estimated to be around 471 million. That might not be the final figure. In fact, it's likely it won't be, but it's in that territory. The FSCS is funded by a levy, and that is a levy paid by authorised firms in the financial services industry. I'll come back to that in a second, but that's important to see where the money comes from in the first place. The FSCS can pursue recovery actions and is in fact obliged under the statutory rules to bring such actions where recoveries are likely to be both reasonably possible and cost effective. That's explained in paragraphs 11 and 12 of Mr. Derbyshire's evidence. And as will be clear, there are two targets, or two main targets. There's the firm in default, often not worth pursuing, but sometimes worth pursuing. And then more attractive target, professional indemnity insurer of the firm in default. Under the 2010 Act, the FSCS, obviously having taken the assignment, able to bring a claim directly against the insurer, and the sums recovered, whilst nothing like as large as the sums paid out, are still significant sums for a body like the FSCS. So we see paragraphs 24 to 26 of Mr. Derbyshire's statement, where he explains that significant sums, they are still significant sums, have been recovered over recent years, since 2020 and so on. And we see that in that context, the FSCS has a keen interest, of course, in being able to pursue claims under the 2010 Act against insurers. Now, importantly, and I said I'd come back to the levy, importantly, recoveries reduce the levy because the levy is estimated annually, and the higher the recovery, the better it is in fact for the industry, because the insurers of the firms in default, if recovery can be made, will pay out. And that has a global beneficial effect for the industry. Another important point, if we look please at page 514, so this is in the exhibit to Mr. Derbyshire's statement. This is the Chief Executive's statement of the FSCS, we see that the starting point is page 512, Outlook, November 2022. It's the penultimate paragraph on page 514, and it's the last sentence. Around 80% of people who need to bring claims to us did not realise they had been given unsuitable advice until at least 5 years after the event. Now, that is untested evidence, but it's evidence of at least something before this court, which is that as far as the FSCS is aware, it's not just the FSCS that, if I can put it in inverted commas, comes to this late. In fact, that's commonplace. It's commonplace for, at least in the FSCS's experience, to have people who need to bring claims not realising until at least 5 years after the event. Now, obviously, that can have consequences in terms of the likelihood or otherwise that the firm will then go into insolvency, and obvious consequences in terms of that rubbing up against the limitation period. Now, it's not inevitable, but this shows that this isn't, the position of the FSCS is by far from unique. This is an obvious problem for normal consumers. If we could then go back, please, to page 506, 506. Oh, sorry, 505, in fact. And the court will have seen this, but just to make the, I think, obvious point, from paragraph 18 onwards, the circumstances in which the FSCS comes to considering whether or not to bring a claim inevitably are quite far down the track in terms of the time periods involved, because quite a lot must have happened. There must have been a default, there'll be an alleged wrongdoing. The FSCS will often be in the position of there being at least 6 years that have elapsed since the relevant cause of action that's assigned to the FSCS has accrued. The FSCS then has to consider a number of matters. It has to investigate whether or not there is a potentially good claim. We've seen the statutory test. The FSCS then also, if we go over the page to paragraph 19.4, has to investigate whether it has viable recovery actions, i.e. it has to consider the insurance position. And that may involve looking into whether there is insurance at all, whether relevant notifications have been made, investigating the terms of the insurance and so on. And so by the time we get to paragraph 21, it's explained that a significant amount of time has often elapsed by the time the FSCS is involved. As it happens, sometimes claims, maybe even often claims, at least some of them are time barred, but it's crucial for the FSCS, in fact, to be able to rely on what it has always understood to be the relevant provisions, the general rolling stock provision, and what I could call it old style approach. And that's a matter of deep commercial importance to the FSCS. As we've seen, as it happens, it's likely it's of great importance to other claimants as well. So that's the context for which the FSCS, or in which the FSCS has an interest in these appeals. And then the court will have seen the written submissions of the FSCS. Those appear in the second core bundle behind tab 79 at page 549. And the FSCS really make 3 points. The first one is the first point I also want to address, which is the answer to the limitation position in respect of a claim for a declaration under the Section 2 procedure falls to be determined by reference to the limitation position applying to the underlying action, if I can call it that, the action on which the declaration is. Oh, sorry, excuse me. So this is our first point. It actually starts on page 551.
Yep.
The summary is at paragraph 3.1 on page 550.
That's the first round of the UB Tiger.
Sorry, excuse me.
The first round of the UB Tiger.
Yes. Yes, if I can I turn to that point first? And so if we go please to the Act, which I'm afraid I had also marked up the first copy, but if we go please to the Act, which is in at the very back of AB4 at page 1530. And we've obviously seen section 1.4 before, the various methods of establishing liability. One of them is 4A, the declaration under section 2, and then we go over the page to 1531 to section 2A. So if we just look at this purely as a matter of statutory construction at this point, so just to look at what the words are and what they do and don't contain. P may bring proceedings against the insurer for either or both of the following. A declaration as to the insured's liability to P. Now, it's actually a very, very brief provision. It doesn't say very much. The reason it doesn't say very much is because it doesn't need to say very much. The legwork, if I can call it that, is actually done elsewhere. All we respectfully submit that section 2.2a is simple, limited, but very helpful provision that allows the third party P to bring proceedings directly against the insurer for a declaration as to the insured's liability to P. It's a short circuit or a proxy, different ways of describing it, all of which I recognise go away from the statutory language and that therefore flawed to that extent. But that's what they are in short form. And it's a short circuit of the otherwise expensive and time-consuming process of P pursuing the insured to judgment and then commencing proceedings against the insurer. Crucially, what this means is the declaration being sought is simply a declaration about the claim that would otherwise have been brought by P against the insured, and that brings with it, therefore, the same rights and defences, as we've seen, that would otherwise apply to that underlying claim, and that's made clear, obviously, by section 2.4. That is clear, actually, from the wording of section 2.2a itself. It's a declaration as to the insured's liability to P. Now,
So if the insured has no liability to P, you won't get a declaration that he is.
yes, absolutely, exactly. And crucially, it's a declaration. A declaration isn't a cause of action. All it is a remedy. I can't bring a claim in declaration, but I can bring a claim in tort or breach of contract. So where do I look for the substance of the rights underlying the declaration sought? Well, the Act tells me I have to look at the insured's liability to P. What does that tell me? I have to look at the nature of that claim. Now, that's completely consistent with well-established authority on this point, which is that the limitation for a claim for declaratory relief is governed by reference to the position governing the underlying action, in other words, the claim on which the declaration is based. So if we could please go to Woodison and Credit Suisse, which is authorities bundle, I think, and I'm afraid to, I've only got 2 authorities bundles, but I know there are 4, so I think it's tab 45. I think it's bundle 3.
Bundle 3.
It is. Oh, I'm with you. Mine are doubles.
I'll explain what you've got.
Yeah, exactly.
Tab 49.
To be clear, I do have all the authorities, but mine are double-sided, and that's why I've got half the. So it is, but it is tab 45.
Yeah.
And so this is a claim about, in broad summary, mortgage mis-selling. And the relevant passage starts on page 664. Well, if we see the heading at page 663, there's a limitation point. and then we really go over the page to 664, and we see the reference to National Bank of Commerce versus National Westminster Bank, the decision of Webster J, which is in fact then criticised in Woodson by Lord Justice Longmore. But the starting point, in fact, is not criticised, and so we look below 22 at the passage set out there. As to the declarations, although action can be brought simply for a declaration in itself is not a cause of action. So that's just a brief point on that issue. But we then see, and this is really it's paragraphs 23 and 24 on which I really rely, these observations were criticised by Professor McGee, who took the view that a declaration could be or become time-barred if the basis of the action was itself time-barred. A declaration that a sum was payable by way of debt or damages would therefore be time-barred if the underlying cause of action was itself time-barred. We have the McGee book, or the relevant chapter of the McGee book, in Authorities Bundle, I believe it's Authorities Bundle 4, it's certainly tab 64. I'm grateful. So it's Authorities Bundle 4, tab 64.
Yeah.
And within that, it's page 1502. And we see the reference to the National Bank of Commerce, reference to Webster J's decision, and then the criticism halfway through. It is submitted that these observations by Webster J display some confusion. It is not correct to say that an action for declaration cannot become time-barred. The vital question for limitation purposes is as to the basis of the action. ... The present action was an action founded on simple contract, and any action for a common law remedy became time-barred after 6 years. This includes an action for a declaration. These observations were cited with approval by Longmore, or Lord Justice Longmore in Woodison. And then, if we then please hop back to paragraph 24 of the Woodison decision, which is on page 664. I don't know if the court still has that open behind tab 45. We see the reference to Mr. Justice Coleman's decision in the P&O Ned Lloyd case. And just to read that first paragraph, the function of the Limitation Act 1980 is to identify those periods of time within which a claimant is permitted to invoke the jurisdiction of the court to grant relief. Those periods of time vary according to the nature of the grounds for relief. Those grounds comprise both the factual foundation and the assertion of a legal or equitable rights consequential upon those grounds. A claim for a declaration that a contractual right has accrued or that a breach of contract has occurred is thus a claim, or in the words of Section 5 of the Limitation Act, an action for relief founded on grounds an essential part of which is a simple contract. And then, if I could just invite the court please to read at the bottom of page 664, just the end of paragraph 24. I'm grateful. And so applying that authority or those authorities to the present case, there are two questions. The first step, or two steps. The first step is to identify the action on which the declaration is based. And here, this is the claim establishing the liability of the insured, since the declaration is being sought in respect of the insured's liability to the third party. That is unsurprisingly consistent with the passages of the Law Commission report to which we've already gone. Just for the court's reference, they appear at paragraph 7 of the FSCS written submissions on page 552. We've already gone to those. It would just be repetition to go back to them. But that's the first step. The second step is then to identify the limitation period applicable to the claim against the insured. And I certainly won't go back through that, but those are the two steps we'd respectfully submit, which does take us to FSCS and LARNL in our circumstances. And crucially, there cannot be any difference between the limitation period under section 22A, because all it is a declaration about something else. The something else gives us the time period, gives us the limitation period, as to which my learned friend has addressed the court already. So that was my first point. It was actually my second point. I addressed my third point is protecting the efficacy of the Section 2 procedure. We've seen various paragraphs of the Law Commission's report already. If I could just go to a couple more references, please. So this is in the Law Commission's report. It's tab 56 of the authorities bundle, which is in bundle 4. And within tab 56 is page 1101, 1101. And at paragraph 1.5, so page 1101, paragraph 1.5. And this is the heading, the need for reform. Unfortunately, the 1930 Act does not work as well as it should. Its basic operation in the context of insolvency has provoked criticism over a number of years from academics, lawyers, the judiciary and litigants. We don't need to turn it up, but at page 1237, there's a list of people and organisations who have commented on the consultation paper, the consultation that preceded LC 272, was LC 152. And the court may well remember all of this going through at the time, frankly. But the crucial point I'm coming on to is that everybody in the market was concerned about the 1930 Act. The claimant side, the insured side, and the insurers. And there was a unanimity, give or take, on the core problems and, as it happens, as I'll come to, the core solutions. We carry on paragraph 1.5. Owing to the way the 1930 Act has been applied by the courts, third parties are often not assisted by it at all, or are unnecessarily required to expend substantial time and money enforcing their rights. We then please go to page 1103, paragraphs 1.10, 1.11, through to 1.13. I won't read them out, but just if I could invite the court please to read paragraphs 1.10 to 1.13, please. Now there's nothing new in those references, but the point that I'd like to draw to the court's attention is that the purpose behind the 2010 Act was to satisfy the whole market, because a concern of insurers was that it costs a lot of money to issue a separate claim against the insured, bring that claim, increase costs, and only then pursue the insurer. If the claim is good under the insurance policy, the insurer, and then at a wider level, the insurance market, picks up the bill. Now that's inefficient. It's costly, it causes delay, it's difficult for insurers on a number of different levels, but the fundamental was that the claimants didn't want to have to spend the time and money making those claims, and the insurers didn't want to have to meet those claims in the end. it also creates potential wasted costs, because if the claimant brought the claim against the insured company, succeeds, and then only then finds out that in fact the insurance won't pay out, that's a lot of wasted time and money. It takes up judicial time, etc., etc. It was a systemic, market-wide issue. So the idea behind a number of the reforms was generally to satisfy the whole market. There's an oddity in this case now is that were, in a sense, the streamlined system not to work, then that would be disadvantageous, not just for claimants, but for the market more widely, because we go back to the, probably inappropriate to call them the bad old days, but go back to the old days where those costs would wind up going to the insurers. It's not beneficial to them either. So the one of the consequences of the judgments below, in fact, would be to produce a distinction in the limitation position between one, a third party who seeks to take advantage of the streamlined mechanism for establishing the insured's liability under the 2020 Act, and a third party who instead issues proceedings against the insured claiming relief outside of the 2020 Act. That undermines the efficiency of the Act, of the procedure, and frustrates the aim of the Act in that insureds may be compelled to issue separate proceedings, claimants may be compelled to issue separate proceedings against the insured. So that's the efficacy of the Act point. I then come on finally to some fairness points. Now, I readily accept that there are always problems with fairness points. If the law is the law, it's all well and good to say, well, that's unfair, because, and the authorities address this point, on one level, it's unfair to have a limitation period. It's an unfair cut-off that Section 5 of the Limitation Act prevents claims. Well, invariably limitation periods mean a balance being struck. But so these fairness issues are designed more to bring to life the practical difficulties that are caused or will be caused if the underlying decisions remain as they are. So we have an example, in fact, in paragraphs 19 to 21 of Mr. Derbyshire's statement, which we find behind, sorry, excuse me, I got the wrong, we find that behind tab 78 of the second core bundle. And I won't run through the example, but it's paragraphs, so page 506 to 507, and it's paragraphs 19 to 21. The practical effect on the FSCS, which to an extent can be said to apply to other claimants as well when they find themselves in similar positions, is that what the FSCS now has to do is, on advice, in the sense that it's obviously sensible to do this, pursue claims against the insured to protect itself, i.e. to proceed under the old approach, because that is the safest way to do it. So issuing protective claims when in fact it might not be necessary. And those protective claims will be issued against the insured and also the insurer as early as possible, as soon as it might be possible to bring a claim applying the statutory test. The FSCS feels compelled by these recent judgments to issue claims, and obviously on a high value claim, the issue fee is £10,000. Many claims, is an understatement, perhaps most claims ultimately settle. If it were possible not to have to issue the claims, that would save a lot of money. That money in fact comes directly from the market because it's funded by the levy. So it's beneficial, as it happens, to the firms, but also to insurers. It's directly contrary to the interests of every market participant for this system to operate in this way, if it does. it is also quite possible that this would give rise to satellite litigation, because if a claim were pursued only again, it's an obvious point, but if a claim were only pursued against the insurer, and given the probably reasonably good market understanding of the 2020 Act, it took a long time to come in, but it's obviously now well established. Many in the market, many solicitors and counsel may well think, well, it's the right thing to do to pursue the insurer alone. That's obviously what Parliament intended. Statutes are meant to work. I'll take a purposes approach. This makes sense. So they do only pursue the insurers. It transpires that's wrong. Well, there's obviously one place to look for the claimant, who will have to pursue their representatives, rightly, if the underlying decisions in this case stand, who will then turn round to their own insurers. And then
Professional liability insurance premiums go up.
well, exactly. That's exactly right. And so it's a systemic issue. It affects the claimants. It affects the insured bodies. It affects the insurers. It affects the representatives of the claimant, and so on and so on. It is really bad for the market if the FSCS's experience is anything to go by. Just one or two brief further points on fairness. Which I may already have covered. If I could have a moment, I'm just keen just to cross these off. Could I just have one moment, please, just to take instructions? I'm grateful. I'm very grateful. In fact, unless I can assist further, those are the FSCS's submissions in opening.
Thank you very much, Mr. Lynch.
My lords, my lady, we propose to make our submissions under 4 headings, and to save having to dictate them, I've typed them up, and wonder if they could you hand them up, please?
Oh, I'm grateful.
So the first submissions, which will be brief, will be in relation to limitation, and there will be 2 submissions. Firstly, a strong public policy against the raising of stale claims, and hence the Limitation Act should be given its full effect. And secondly, Parliament has struck the balance, and it's not for the courts to alter this. Then we will make submissions about the insolvency regime. In effect, 2 submissions. The liquidator is required to admit to proof any claim which was a valid claim at the commencement of the liquidation, even if it became statute barred before the proof was lodged. This duty overrides any limitation defence, but does not alter the limitation period. It is limited to liquidations and bankruptcies, and it is limited within those to creditors proving therein under the collective enforcement procedure. Thirdly, we'll be submitting in relation to the 1930 Act and Larnell that the current Act should not be construed by reference to the 1930 Act. In any event, only the Supreme Court can reverse Larnell, but the Court of Appeal should not extend its ambit to the 2010 Act. And then finally, on the 2010 Act itself, Section 1 retains the same principle that the right of the insured. In my skeleton argument, I referred to X, Y, and Z, which I hope is a convenient shorthand, where X is what's been called the third party in the Act, the victim, as it were. Y is the insured, and Z is the insurer. Y's right to be indemnified by Z against any liability to X is transferred to X upon Y's insolvency. Section 2 creates a new procedural right for X to sue Z direct without first having to establish liability against Y. No new cause of action is created. The effects of Section 1 and Section 14 is that Y's right to be indemnified by Z is automatically transferred to X upon insolvency and never falls into the insolvent estate. Hence, the difficulty perceived in Larnell does not arise under the 2010 Act. Sections 2 subsection 5 and section 12 are the only provisions in the Act which deal with limitation. The Law Commission report and the explanatory notes can't alter the plain meaning of the words in the Act, and in any event do not purport to do so. And finally, if the appellants were correct, the result would be arbitrary and unprincipled, because in the case of companies in administration, creditors, CVAs and IVAs, the ordinary limitation period would apply. For liquidations of bankruptcy, general rolling stock would apply. And for dissolved companies, the limitation period would either be 6 years from the date of dissolution, according to one version of the learned friend submissions, or unlimited on another version. So
Is it
that's the framework.
that rolling stock doesn't apply to companies in administration at any rate where they are distributing administrations?
I'm afraid we don't have the authority with us. I can bring it over tomorrow morning. But there is an authority, first instance authority, which is reported from Mr. Jules Sher, QC.
That was before administrators had the power to make distributions, I think.
Yeah, that may be so.
And he did decide that, but I think
Yes.
since the power of administrators has been enlarged, query whether that still applies.
I'll check that overnight if I may. So that's the general framework, the structure that we propose to adopt. And of course, what this case concerns is the intersection between three different statutory regimes: the limitation regime, the insolvency regime, and the Rights Against Insurers Act regime. And the question is how they interact. We can take limitation relatively briefly. The Zedra case, for the court's note, is in the bundle tab 52, starting at page 802. I don't need to read it out, but what I just ask the court to note is the passage from my Lord Justice Lewison, which runs from paragraph 11 through to paragraph 19. It's pages 806 to 7. Beginning with the words, "There is a strong public policy against the raising of stale claims." And then he gives no fewer than 5 examples of that. And perhaps the most striking one, I'm sorry, my lord.
Which tab?
It's tab 52. In volume 3, I'm so sorry.
Thank you. And you were reading from where?
So it's page 806. And the first sentence, "There is a strong public policy against the raising of stale claims." Pausing there, learned friend Mr. Lynch made the point that limitation periods can be said to be unfair. With respect, I dissent from that. What this case is saying is that is that limitation periods themselves are important because there is a strong public policy against the raising of stale claims. Then examples are given, and perhaps the most striking one is at paragraph 15. Striking because it's an extract from a dissenting judgment, judgment of Lord Sumption. And the second half of the quotation at paragraph 15, I draw particular attention to. Limitation reflects the fundamental and all but universal legal policy that the litigation of stale claims is potentially a significant injustice. Delay impoverishes.
You will at some stage identify the policy that would give an insurer a better right to claim limitation than the underlying insured.
I submit there is no difference. I accept that. The other thing I'd ask the court to note on this is paragraph 19, where Lord Justice Lewison makes the point that in claims that are purely equitable, there is no limitation period in the Act, but nevertheless, the courts have applied a period by analogy. So that's the strong public policy. My learned friend referred to the case of Smith and RBS, which is in tab 51, the previous tab. Of course, what was said by Lord Leggett about section 994 has been overtaken. His other point about there being no limitation period in equitable claims is also met by Lord Justice Lewison's observation that the courts will apply the statute by analogy in equitable claims. So our submission is that, to put it in simple terms, limitation periods are a good thing in principle. That's our first submission. And our second submission on limitation we make by reference to Howard and Fawcett, which is in volume 2 of the Court's Authorities Bundle, tab 32. I'm sorry, I've given you the wrong reference. I've given you the wrong reference. Tab 39, I'm so sorry.
Fawcett's.
That's in volume 2. And the relevant passage is in paragraph 32 at page 472. Well, this was a claim under, in relation to section 14A of the Limitation Act. It was a negligence claim against an accountant. And I invite the court to look at what Lord Scott says in paragraph 32 at page 472.
Yeah, your points between G and H.
Yes. Yes. So the conclusions that we draw from Zedra and from Howard and Fawcett are, firstly, there is a strong public policy against the raising of stale claims, hence it's a good thing if the Limitation Act applies. Secondly, we accept that one cannot force a claim into the ambit of the Act if it doesn't fit there, but equally, one should not be astute to find ways of saying that the Limitation Act does not apply. And thirdly, Parliament has struck the balance, and where the Act does apply, the Court's duty is simply to construe the Act fairly, and not with a view to rewriting it. Those, unless I can discuss further, are our submissions on limitation. We then move to the insolvency submissions, and the starting point is the general rolling stock case. Court's not yet been taken to it, and although it's very well known, court probably should be shown the case. So it's in volume 1, tab 19, starting at page 89. And the judgments are those of Lord Justice James beginning at 91 and Lord Justice Mellish beginning at 92.
Do you want to just read that? Should we just read those to ourselves?
Please, yes. So the case establishes that there is a statutory trust for creditors at the date of the winding up. There may be an issue which doesn't arise in this case as to whether the date of the winding up is the date of the petition or the date of the order. That perhaps I can park that because it makes no difference on the facts of this case. Obviously, we're concerned there with the 1862 Act, but this remains good law under the 2006 Act. It applies to liquidations and to bankruptcies, subject to the point my Lord Justice Lewison raised, which I will check overnight. It does not apply to administration orders. The case I had in mind was the case of Re Maxwell Fleet, 2001 on Weekly Law Reports. It's not in the bundle, but I'll check overnight whether the position has changed as a result of administrators being given wider powers. But certainly the basic principle when administrators were introduced was that they had no power to distribute, and hence general rolling stock didn't apply. In the case of dissolution and restoration, limitation continues to run on during dissolution, which is why, as my Lord Justice Lewison said, it may be necessary to apply for a limitation direction, although one may not receive it. It does not apply to proceedings outside liquidations and bankruptcies, and there's a few authorities on this, which I can take very briefly. The first one at tab 20 in volume 1, sorry, tab 20, yes, is Re Benson, 1914, Court of Appeal decision, page 94. What happened in this case was that Mr. Benson was unfortunately bankrupted twice on successive occasions and then died 9 years later without ever being discharged. He held a general testamentary power of appointment, which he exercised by his will, and the creditors in both bankruptcies claimed the fund. But it had previously been decided that a power of appointment by will did not fall into the bankrupt estate, did not pass to the trustee in bankruptcy. Hence, it was claimed by the creditors in an action outside the bankruptcy. And the decision was given by Mr. Justice Chancellor in the Court of Appeal, begins at page 99. The court will see at page 100, in the middle of the page, we see the man died in 1911, having made a will by which he executed general power of appointment. And then we see in Re Guedala, the first point was decided that such a fund, though assets for the payment of debts, was not property passing to the trustee of bankruptcy. So that's the basis on which the matter proceeded to the Court of Appeal. And then the key passage begins on page 75, about a third of the way down, could I invite the court to read the rest of 75 and the first paragraph of 76?
I see from page 73, 99 of our bond, the rolling stock was cited.
Yes, I was about to mention that. Yes, that's correct. It was before the court. So what this case shows is that where the asset in question does not fall into the bankruptcy, then the general rolling stock principle doesn't apply to it, and the ordinary limitation period applies. That's the first relevant authority. The next one is Cotterell and Price in the same volume at tab 23, starting at page 133, 1960, a decision of Mr. Justice Buckley.
Sorry, can you give me the
Sorry,
tab,
yes,
please?
my lady, it's tab 23. The decision starts at 133. And this was a case in which a mortgagee was claiming on his security and hence outside the bankruptcy. And if the court would go please to page 141 in the bundle, or sorry, starting at 140 in the bundle, halfway down the page we have a reference to re Benson. And then the first full paragraph at 141, the importance of that case, that's Benson, and of the way in which the doctrine is stated in the judgment, is that it makes it clear that it's only in the bankruptcy that the statute ceases to operate. It doesn't have any effect on the operation of the statute on rights and remedies, which are unaffected by the bankruptcy. A mortgagee who relies on his security right retains and stands on rights which he had before the bankruptcy and remain unaffected by it. So that's another way in which general rolling stock doesn't apply. A third way in which it doesn't apply is the case of Anglo-Manx, which is in the next volume, tab 32. Page 314. decision of Mr. John Jarvis, you see. And what this case involved was an unsecured claim that would normally have fallen into a bankruptcy, but the claim involved an allegation of fraud, and therefore the bankrupt wasn't discharged. Or the bankrupt on his discharge from bankruptcy would remain potentially exposed to that claim for fraud. And that is clear from it's paragraph 60 on page 331 and 66 on page 333. So at 60, Mr. Jarvis says, considerable argument before me as to what's meant by in the bankruptcy as distinct from outside it. Mr. Adair submitted, the question can be formulated in this way. Is the claim being directed at property within the statutory trust, or does it relate to property outside of the trust? For example, after acquired property, or property which cannot form part of the estate. Seems to me that is the correct formulation and is consistent with Cottrell and Price. I should say that that is qualified in Larnell for the court's note at paragraph 35 of Larnell on page 453. That test is qualified. And then at paragraph 66 on page 333, he says, it seems to me the judgment in Benson is binding authority on me, and there is nothing to indicate it's based on any false premise. Result of that decision is that the statute of limitations, having begun to run against the claimant before the commencement of the bankruptcy, continues to run, notwithstanding the bankruptcy, in respect of a claim in relation to a fund pursued outside of the bankruptcy. The fund, of course, being after acquired property on the basis that the bankrupt had not been discharged from the debt because it was a claim based on fraud. Now turn next, please, to tab 35, the decision of White and Eckhart in the Privy Council, starting at page 370. And there's just one paragraph here from Lord Hoffman, beginning at page 378, paragraph 27. Where he says, the winding up leaves the debts of the creditors untouched. It only affects the way in which they can be enforced. When the order is made, ordinary proceedings against the company are stayed, although the stay can be enforced only against creditors, subject to the personal jurisdiction of the court. The creditors are confined to a collective enforcement procedure that results in pari passu distribution of the company's assets. The winding up does not either create new substantive rights in the creditors or destroy the old ones. Their debts, if they are owed, remain debts throughout. They are discharged by the winding up only to the extent that they are paid out of dividends. But when the process of distribution is complete, there are no further assets against which they can be enforced. There is no equivalent of discharge of a personal bankrupt which extinguishes his debts. When the company is dissolved, there is no longer an entity which the creditor can sue. But even then, discovery of an asset can result in the company being restored for the process to continue. The FSCS in their written submissions say that White was not concerned with limitation. They say that in paragraph 21 of their submissions. We say, yes, that is true, but what Lord Hoffman was stating was a general principle. The cause of action is unaffected, and that would extend to the limitation defences that would potentially be available, subject to the rule in general rolling stock. This brings me to my final submission, my final authority on the insolvency question, and it is in volume 3, tab 52A. of Lord Justice David Richards.
So, just pausing for a moment.
Yes.
Are you saying this, that there is a single liability, namely the liability of the insured to the third party?
Yes.
There are two potential methods of enforcing it.
Yes.
One is through a collective insolvency procedure,
Yes.
and that you are confined to that method once there has been an insolvency. The other way of enforcing it is by action, and the Limitation Act, which prevents enforcement by action. Is that what you're saying?
More or less, but subject to one qualification, which is that the right to bring an ordinary action is barred in the case of a compulsory liquidation unless you get relief permission under section 130. It's not barred in the case of a creditor's voluntary unless the court makes an order stopping it. And this is precisely the point that I want to take you to in Mortgage Debenture and Chapman. I should say the judgment begins at 846, and you'll see from paragraph 1, it's a point of construction on the provisions for a moratorium in connection with administration. We're not concerned with that at all. But the relevant passage is paragraphs 11 and 12 on page 848 to 849. So administration as an insolvency procedure was introduced by the 1986 Act, but moratorium has long been a feature of compulsory liquidations. Then he sets out section 130 of the Insolvency Act 1986, which says no action should be proceeded with against a company except by leave of the court, subject to such terms as the court may impose. Similar provision exists as regards bankruptcy of individuals. There is no automatic moratorium in the case of a creditor's voluntary winding up, but the liquidator may obtain a stay against the company by application to the court. In the case of liquidation and bankruptcy, the purpose of these provisions is essentially twofold. First, given that the property of the company or individual stands under the statute to be realised and distributed, subject to any existing interests among the creditors on a pari passu basis, the moratorium prevents any creditor from obtaining priority and thereby undermining the pari passu basis of the distribution. Secondly, given that both the liquidation and bankruptcy contain provisions for adjudication of claims by persons claiming to be creditors, moratorium protects those procedures, prevents unnecessary and potentially expensive litigation. Where there is potential liability of the company or bankrupt is best determined in ordinary legal proceedings, as for example, is often the case with personal injuries claim, court will give permission for proceedings to be commenced or continued, but usually on terms that no judgment against the company or individual can be enforced against the assets of the estate. Now, it's that first sentence of paragraph 12, which I submit is the critical one for these purposes. Because what Lord Justice David Richards is saying is that if you have a creditor's voluntary, where you're not automatically prevented from bringing proceedings, ordinary proceedings, against a company in liquidation, if you were to get judgment, you would jump the queue. That's why I say, in the submission that I handed out to the court.
Why would you jump the queue if you get judgment? Judgment doesn't make any difference.
Well, if you get judgment and enforce it.
Well, yes, but the and enforce it is important, Mr. Halpern.
Yes. Oh, yes. But you would
It's
not
critical.
be. Yeah, but you would not be prevented from enforcing it unless some steps had been taken. That's why, as Lord Justice David Richards says, where leave is given, it's usually on terms that no judgment can be enforced. But if you didn't have that provision, you'd be able to enforce it.
Save in circumstances where leave is given in order for you to pursue an insurer.
That may be so, but my lady, the key point in my submission, as a matter of analysis, is that what inside the liquidation means is inside the collective enforcement machinery. And the court may well take steps to ensure that things have to be done inside that machinery, but the case makes it clear that of itself, the liquidation doesn't suspend limitation. So we submit that the phrase outside the liquidation or outside the bankruptcy covers several different situations. And the ones that we've seen so far, and there may be others, firstly, claims to assets which do not fall into the liquidation, and that's Benson. Secondly, claims by creditors who claim a proprietary interest, and that's Cottrell and Price. Thirdly, claims against insolvent debtors who remain personally liable notwithstanding bankruptcy, and that's Anglo-Manx. And finally, claims which do fall within the liquidation or bankruptcy, but where the creditor seeks to sidestep the collective enforcement procedure by bringing proceedings as an unsecured creditor and isn't stopped from doing so. Now, in practice, the court is likely to stop it in order to make sure there's no unfairness, but that doesn't affect the analysis. The analysis is that it's only inside the liquidation if it's being done under the collective enforcement procedure. And that highlights the point that there is only one limitation period. Of course, it's a procedural rule, as my Lord Justice Lewison has said, but there's only one limitation period, but there is a different rule which prevents the liquidator from relying on that within the collective enforcement procedure, and the courts have the power to take steps to ensure that things are brought within the collective enforcement procedure and not outside it.
Well, because it's a collective procedure, it's not an action.
No,
So the limitation period never does apply.
no, indeed, indeed,
Limitation period only stops you bringing actions.
absolutely, absolutely, and therefore limitation has nothing to do with this rule.
So it's not a question of suspending the
Absolutely,
limitation period as such. It's, if you like, sidestepping the whole question of limitation
yes,
by means of a different enforcement regime.
precisely, precisely.
It means you end up with some kind of distribution in relation to a stale claim.
Yes, you do, but within the collective enforcement procedure. And question will then be how that translates when we're looking at a claim, firstly under the 1930 Act and now under the 2010 Act. But it's an oversimplification and indeed wrong to say that limitation has been suspended. My lords, my lady, that brings me to the third submission, which is as to the 1930 Act and Larnell. And firstly, we say that the 2010 Act should not be construed by reference to the 1930 Act. Quite a lot of authority has gone into the bundle, most of it, I'm happy to say, not from us, about how one construes statutes. The one case that I would like to take the court to is in volume 1, tab 28, decision of Mr. Justice Hoffman, as he was. Tab 28, page 233, in the case called Rear Debtor, decided in 1992. So this was a case involving the then relatively new Insolvency Act of 1986 and whether it should be construed by reference to the Bankruptcy Act 1914. At page 237 in the bundle, at letter H, Mr. Justice Hoffman says those authorities show in approaching the language of the 1986 Act, one must pay particular attention to the purposes and policies of its own provisions and be wary of simply carrying over uncritically meanings which had been given to similar words, I underline the word similar, in the earlier Act. It does not, however, mean that the language of the new Act comes to one entirely free of the intellectual freight which was carried by words and phrases in earlier bankruptcy or other legislation. So he's not, of course, saying that one ignores the earlier acts, but one has to treat them with a bit of care. And it's really only insofar as the language is similar. And we say that although ideas, concepts in the 1930 Act, some of them have been carried over into the 2010 Act, it is a lot more than simply a reenactment or consolidation, and the language is not similar. And therefore one needs to look at the 2010 Act on its own terms and not by reference to the 1930 Act. Turning to the 1930 Act, which I'll take relatively briefly for the reasons that I've indicated, the first decision of note was the Post Office and Norwich Union case. The court's already been referred to it. It's at tab 24, page 143. The only thing I would add to what learned friend said, all of which I agree with, is that it took 30-something years for this point to arise, and it was by no means, I'm not of course suggesting for a moment that the decision is wrong, but it was by no means an obvious decision. And I say that because the first instance judge was Mr. Justice Donaldson, as he then was, later Lord Donaldson, and he reached the opposite conclusion. And of the three judges, there were two reasons given for the decision. One reason, the broader reason, sorry, I want to just turn it up. So it's tab 24, page 143. And you'll see at the top of 145, the decision of Mr. Justice Donaldson was reversed. And Lord Denning and Lord Justice Salmon gave two reasons. The first reason at 153 is the one that my learned friend has read out, about a need to establish rights. The second reason given is at 154, starting at letter F. When the rights of the insured are transferred to the injured person, they're transferred on the ordinary understanding, subject to conditions in the contract. And then condition 3, no admission is to be made, a completely standard provision. So that's the second reason given. Lord Justice Harman gave the next judgment at the bottom of page 155. He decides the case solely on that second ground, and that appears at 156, letters E to G. And then Lord Justice Salmon decides it on both grounds. So the reason I make that point is that insofar as one's looking for Parliament's intention, there's nothing to indicate that Parliament in 1930 had thought this through. Clearly by 2010 they had, because it features very largely in the Law Commission reports and in the Act itself. But there's no indication that it was in anybody's mind back in 1930. That's the first relevant decision. The next one is Bradley and Eagle Star, which is the next authority, starting at tab 25. And the relevant passage is in the speech of Lord Brandon at page 171 in the bundle, between letters C and E, where he notes that the Act was passed to remedy a particular injustice, not passed to remedy any injustice from other matters, in particular not passed to remedy any injustice which might arise as a result of dissolution of the company, making it impossible to establish the existence and amount of the liability of such company to a third party, not contemplated by the legislature at all. So the Act had a limited purpose. If I may then go to tab 33, case of Matterdine in the Privy Council, tab 33, page 336. This concerns a statute in Trinidad and Tobago, but in substantially the same terms. So the statute is at page 342. We don't need to read it, but just for the court's note, it's at paragraph 20, and 21 says that the sections of the Act appear to follow almost word for word sections 1 to 3 of the 1930 Act. One of the arguments was that the rights amounted to a specialty and hence had a different limitation period, and that was rejected by the Privy Council at paragraph 38 on page 346. Detection that section 17 action was action based on a statutory obligation, and for that reason an action on a specialty was rejected by the Court of Appeal. In the Lordship's opinion, the Court of Appeal was correct. This section affects a statutory transfer to the injured party of the insured's contractual rights against the insurer. It does not create a new cause of action. And then going down to the underlined bit, in England, the insured's right to claim indemnity against his liability would be transferred to the third party by section 1. His right to claim the cost of repairing his car would vest in the trustee in bankruptcy. In both cases, there would be a statutory transfer of contractual rights under the policy from the insured to the statutory assignee. What would be transferred would in both cases be the contractual rights, warts and all. In neither case would the statutory assignee require a new cause of action. And we say that that remains the case under the 2010 Act. So what that makes it clear is that the limitation period between what I call X and Y, that's to say the third party making a claim and the insured, is the same as it would have been if there were no 1930 Act. It's the basic limitation period, unaffected. Limitation period between the victim X and Z, the insurer, is the same as the period would have been between Y, the insured, and Z. In the case of liability insurance, it's 6 years from the date of that liability being established. I don't think there's any dispute between my learned friends and myself
I
on
must say,
that
I
point.
find this little bit of the judgment in the opinion in this case quite difficult to understand. The positive example is there's an accident caused by the insured's negligence.
Yes,
Consequence is the third party is injured and the insured's vehicle is damaged.
yes,
He goes on to say, at the sidelined part, that his right to claim the cost of repairing the car, that is the insured's right,
yes,
should vest in his trustee under the Insolvency Act. So part of the rights under the insurance policy are in the bankruptcy. Part of them are not. That's presumably the third party can sue the insurer.
yes.
So that is not, as in the post office case, contemplating the transfer of everything for which the insurer is liable. It's only the compensation to the third party. Is that right?
I'm afraid I hadn't focused on that. May I think about it overnight?
Yes. So I thought one of the points that was being made about the 1930 Act was that
Yes.
it was all or nothing, everything.
Yes,
But that doesn't seem to be what Lord Scott is saying here, if I've understood. what
I
he's
understand
saying.
your Lordship's point. If I may, I'll reflect on it overnight. That brings me to Larnell, which is tab 34, beginning of volume 2. Sorry, not tab 30, tab 38, I beg your pardon. 38 of volume 2. Can I begin by making it clear what we are and are not submitting in relation to Larnell? If this case were to proceed to the Supreme Court, we will submit that Larnell was wrongly decided. We accept that it's not a submission that's open to us in the Court of Appeal in these proceedings. Nevertheless, we submit it's relevant to consider why, in our respectful submission, Larnell was wrongly decided, because there is no good reason to extend that error to an act which is differently worded. So that's the reason why I'm taking you to Larnell. And we say that the error is not only unwarranted, but is also contrary to the public policy in Zedra. So this involved a case where investors sued an IFA for negligent advice, relying on Section 14A of the Limitation Act. The IFA was wound up just inside the 3-year period. The investors were compensated by the FSCS and assigned their claims to them, and then the FSCS issued proceedings. The decision was decided the other way by Mr. Justice David Steele. So once again, we say this is not a point that was obviously in anyone's mind at the time of the 1930 Act, or indeed at any time over the next 70 years. Until the Court of Appeal gave judgment. Now, my learned friend took the court to paragraph 11 of Lord Justice Lloyd at page 446. And if I may, I'd like to go back to that. Paragraph 11, just below letter F, he says, if proceedings are necessary, they may take one of a number of forms. The obvious instance is a claim such as the present, because it's a voluntary winding up, unnecessary to obtain consent. If the winding up were compulsory and court permission were needed, the court might regard it as more appropriate to prove for the debt, and if that were rejected, the third party could appeal. That would lead to a judicial determination, which would also be sufficient establishment of the liability of the insured. Nothing turns on the particular procedure adopted. It makes no difference whether the proceedings themselves are brought within the bankruptcy or winding up proceedings or outside them, as in the present claim. We submit, with great respect, that's not correct because of what Lord Justice David Richards explained in the Chapman case. You do get a different result if you were to bring proceedings outside the liquidation and were not stopped from doing so. That's the reason why you're likely to be stopped. It does make a real difference. Then moving on to paragraph 13, a passage that's highlighted.
But the other point is that Benzon says that if you bring proceedings outside the bankruptcy or winding up, it does make a difference.
That's correct.
I mean, they do go on to consider Benzon.
They do indeed. But of course, the particular issue in Benzon is not one that arose in this case. That's why I needed to refer to Chapman as well. Chapman was, for my purposes, a stronger case because it was the kind of asset that fell into the liquidation. But the fact that it could be brought outside it unless stopped shows what's meant by inside the liquidation. Whereas in Benson, the asset was never in the liquidation or bankruptcy. So paragraph 13 must describe the position in an insolvency as regards debtors' liabilities, refers to section 107 of the Insolvency Act. Similar provisions apply in a compulsory winding up and in bankruptcy. Then he refers to general rolling stock. The court held that a claim which was still in time at the date when the winding up was commenced, but which was not asserted by way of proof until after the normal period of limitation had expired, was to be admitted to proof because it was in respect of something which had been a liability at the commencement of the winding up. In effect, so far as the operation of the winding up is concerned, limitation periods cease to run. And it's those words, in effect, which I submit are the critical words, because it doesn't actually suspend anything at all. It may appear to have that effect in practice, but it doesn't suspend anything. Then at 16, he refers to White and Eckhart. And at 18, he accepts, of course, that Lord Hoffman's analysis is correct, and that Judge Paul Baker, in a case called Taft Wells, was wrong to describe a creditor's rights as being converted into a trust. So far as necessary to ascertain what the creditor's rights are, they have to be established in contract, tort, or otherwise, as the case may be. Creditor's cause of action remains the same, that's obviously correct. It's only as regards giving effect to those rights in the insolvency that the rights are subject to the statutory trust resulting from the distribution, duty of distribution imposed on the liquidator. Correspondingly, it's as regards giving effect to those rights in that way, by virtue of the principle established in general rolling stock, the period of limitation ceases to run when the liquidation or bankruptcy commences. And we say the devil's in the details. The word correspondingly, which with respect contains the error of assuming that because a statutory trust is imposed and there is a procedural duty on the liquidator to give effect to all claims, therefore limitation has ceased to run. That's not the case at all. Moving on.
Well,
Sorry.
and just so I understand what the point is you're trying to make here.
Yes.
And this is a decision of this court, which is binding on this court. Never
Yes.
mind what you might or might not say, were you to ever get to the Supreme Court.
Yes.
And the Lord Justice Lloyd says in terms there that the period of limitation ceases to run when the liquidation or bankruptcy commences.
Yes.
So that's not saying that limitation isn't suspended at all. It's saying the limitation ceases to run. And in fact, although you make much play of the words in effect
Yes.
in the previous paragraph you referred us to, it's exactly the same point he makes there.
Yes.
That
Yes.
the normal period of limitation ceases to run.
Well, my lord, it is not. It is not a defence that is open to the liquidator, but it hasn't ceased to run. That's my point.
Your
Moving on
point
to-
is that the only person who can't take a limitation point is the liquidator.
Yes, precisely.
And therefore, you say, that doesn't stop the insurer from taking it, even if the consequences are those which have been adumbrated by your opponents.
Yes. Yes. And that the 2010 Act is differently worded, as we'll
And it
see.
drives a complete coach and horses through Parliament's intention and creates all the problems that have been pointed out by the FSCS.
My lady,
You say,
I'll,
Tompy, that's hard luck, limitation overrules everything.
my lady, no, that's not my submission at all. My submission, which I'll probably not get to till tomorrow, is that those problems don't exist. That there is a coherent scheme, and it makes no difference which way whether one brings the action under the new streamlined procedure or under the old procedure, both of which involve the new Act. The result will be the same. But it'll take me a while to get to that, and that will be a matter for tomorrow.
Can I put this scenario to you and just tell me how it works?
Yes.
Let's suppose that company owes a debt,
Yes.
goes into liquidation,
Yes.
but there is a surety for the debt,
Yes.
and the creditor sues the surety.
Yes.
How does limitation work in that scenario?
The-
You said to my lady that only the liquidator is barred from raising a Limitation Act defence. Can the surety raise it?
That's a very interesting question. If I may, can I add that to my shopping list for tomorrow?
Try chapter 7.
I'm sure my lady's book has the answer.
I think you might find
I
chapter
think that answer might be in my lady's book.
That's why I said.
Yes, we shall certainly look at that overnight.
It might be chapter 13, it might be the insolvency chapter.
I'm very grateful for that indication. Can I move on to paragraph 33 on page 453? Now, what he's looking at here is mixed claims. This is the paragraph that's underlined. And he's saying there may be, just above letter D, there may be assets available to general creditors as well as the policy available to third parties. As in the present case, the policy may not be sufficient for the third party's claim if made out in full by reason
Which
of a cap.
paragraph are you on?
I'm sorry, this is paragraph 33 on page 453.
Letter D.
And I was looking at letter D, my lord.
Right.
So he is considering the possibility of a cap or a deductible or a defence available to the insurer, a policy defence, in other words, which is not available to the insured, and is saying that in such a case the third party would need to rely on its right to prove in the liquidation as well. So he's considering the possibility of a mixed claim. In the present case, certainly in theory there could be a mixed claim. In practice, there would never have been a mixed claim for a very simple reason. My learned friend said it wasn't clear what reason there was for dropping Heatwave as a defendant. We don't know for certain, but there is a pretty good indication in the supplementary bundle at page 32 in tab 5, where the insolvency service
Can you give us the,
is certainly page 32, tab 5.
thank you.
The insolvency service saying regarding the questions asked in Richard's email, 1, there are no funds in the liquidation with which to make a distribution to creditors. And that's presumably why this was entirely academic.
When was that? 3 years later. 2023.
But of course I accept in a different case there might be funds, and I accept that it's important to have an answer that's consistent and principled in both situations. So Lord Justice Lloyd continues on page 453, for the letter D. It doesn't follow the third party will be satisfied at all with the policy. In that case, the third party would need to rely on its right to prove in the liquidation as well if there are any assets available to creditors. Its right to do so would be settled by success in the claim. Thus, pursuit of a claim such as the present may serve 2 purposes, both against the insurer and against the funds in the liquidation. And that's clearly an important part of his reasoning. And then at 34, as far as the third party's claim to share in the funds available to creditors is concerned, general rolling stock applies. And then he asks, how can it be said that the third party's claim, which is not statute barred as against the defendant, for the purposes of claiming in the liquidation, is barred insofar as it may be used to fund a claim under the 1930 Act against the insurer. He considers a submission by Mr. Tolley over the page at the top of 454, third line down. In the end, Mr. Tolley's submission was that the test would not be one of intention or purpose. It would be a test of result, if and to the extent that the establishment of the claim would result in a claim to the proceeds of the policy under the 1930 Act, time would continue to run against the third party despite the onset of liquidation, whereas if and to the extent that it would result in a proof in the liquidation, time would not run against the claimant. And then he talks about mixed claims, and he says at 36, this proposition poses both conceptual and practical problems. How can a single claim in respect of one cause of action against one defendant be barred by limitation for one purpose and not for another? And that's crucial to his decision. And he goes on to say separate causes of action may be treated differently. But claimant in the present case only sues a single defendant on one cause of action in tort. Difficult to see how pleaded limitation will be treated on the statements of case and how it would be dealt with when giving judgment for the claimant. And then at 37, in my judgment, Mr. Tolley's proposition faces insuperable difficulties, given that the first stage for a third party such as the claimant is to establish liability to it of the insured, which is necessarily being administered in insolvency. It seems to me that the third party's claim against the insured is one to which the normal principles apply. Namely, if it's not time barred at the commencement of the bankruptcy or winding up, it doesn't become time barred by the passage of further time. And then he notes that the the Law Commission have already reported on the amendments to the Act. It says nothing in the report seems to call into question the conclusions I've reached. So the reasoning,
If you go back to the question that Lord Justice Lloyd
yes,
poses to himself, that is in the context of the two-stage procedure.
precisely.
If you reframe the question and ask yourself, how can a single claim of one cause of action be precluded from enforcement in by one method, but not by another?
Yes,
You don't have the same conceptual difficulty.
yes, precisely. I'm grateful. That's a more elegant way of putting it, but that is precisely the point. So that Lord Justice Morbick is to much the same effect, but he gave a separate judgment, so I should take you briefly to that. His judgment begins at the bottom of page 457. And at paragraph 52, going over the page, he concludes paragraph 52 by saying, follows the company's rights under the policy do not form part of the assets available to creditors in the liquidation. That's the effect of the 1930 Act. And then he refers to the cases that I've taken you to, Benson, Anglo-Max, Cottrell and Price. That's at paragraphs 58 through to 60. And then at 61 to 64, he states his conclusion, which my learned friend has taken you to. If I can just highlight a couple of points. At 63, he says, in the present case, as Lord Justice Lloyd has explained, the claimant's rights against the company could be established by proceedings in the ordinary way, this being a voluntary liquidation, or by appeal against the refusal to admit the proof. But in either case, if it were successful, it would establish its right to prove in the liquidation. By doing so, it would complete its cause of action. That doesn't mean the claim is one made outside the liquidation, or the present proceedings are proceedings to enforce claims against property outside the liquidation. They cannot be, since no rights exist until the company's liability has been established. And then at 64, he makes the same point. Can't accept that the same claim can be time barred for one purpose for another. So I make the same submissions on that as I do on what Lord Justice Lloyd says. And I submit that in summary, I make two submissions. One is that the correct analysis is the analysis of Lord Justice David Richards in the mortgage debenture and Chapman case, that all one is concerned with is whether or not this is a claim that falls within the collective enforcement mechanism procedure in relation to bankruptcy or liquidation. If it does, then general rolling stock applies. If it doesn't, then general rolling stock does not apply, whether or not it is a claim that could have been brought within the collective enforcement procedure. That's my first submission. And my second submission
Can you say that again, please, so that you can
Yes.
get it at dictation speed?
I'm so sorry. The relevant question is that stated by Lord Justice David Richards.
Is the claim which falls within the collective enforcement?
Is the claim being enforced pursuant to the collective enforcement procedure in the liquidation or bankruptcy? It is only if it is within that procedure that general rolling stock applies.
And you say it makes no difference if it could have fallen within that procedure, but it isn't in fact that a different procedure is used.
That's correct, although I accept that the court may well prevent one from sidestepping the general rolling stock procedure. But if they don't prevent it, then it is outside. And what that shows is that the limits of the general rolling stock are not just those of cases like Benson, Cotterill and Price, Anglo Max, but also claims that would squarely fall within the collective enforcement procedure were that procedure to be used.
Well, a mortgagee suing for his money would be one such thing.
If he chose to sue for his debt rather
Could have
than...
been brought within the collective enforcement.
Absolutely.
Doesn't
If he
have
chose to sue for his debt rather than for his proprietary interest, that would fall within the collective enforcement procedure if he did it by proving in the liquidation. But if he brought separate proceedings and the creditors voluntary outside the liquidation and was allowed to continue those proceedings and to wasn't prevented from enforcing them, then it would fall outside. But both aspects would fall outside. One aspect, the proprietary one, would always be outside, and the other aspect would be outside if he was allowed to continue proceedings. So that's my first submission on Larnell, and my second submission is that the decision was reached as a result of the wording of the 1930 Act. Because the 2010 Act is differently worded, there's no reason to carry over the effect of Larnell. One has to look at the wording of the new Act. Well, unless I can insist further on the 1930 Act and Larnell, those are my submissions on that aspect. And that brings me to the final and most important area, which is the 2010 Act itself. I see it's 4:15. How long does your Lordship propose to speak for?
I don't mind, as long as I'm going to be good if we could finish tomorrow.
Well, we think, we're very happy to finish now, provided it's not going to prevent us from finishing the appeal tomorrow.
I'm making pretty good progress.
It sounds as if you're making pretty good progress.
Yes.
I thought that if we start at 10:30, can you sit slightly later tomorrow?
Yeah, absolutely.
Yeah. I think we should try and sit to finish tomorrow if we can. But let's break now.
Thank you.
Mr. Bailey, is that?
Well, my lord, I'm just speculating, given the progress my friend's made, that there shouldn't be any difficulty at all
No, that's what I was
finishing
thinking.
tomorrow. I certainly will
Unless
be making every
we
effort.
start going incredibly slowly, and you are unbelievably verbose in reply, I thought we'd finish well within tomorrow without any difficulty.
That'll certainly be my aim and intention.
Very well. 10:30 tomorrow morning, please. Thank you.
Pot roast in favour.